Good morning, everyone. Welcome to our Spring Employment and Immigration webinar. I'm Devan Khagram. I'll be chairing today's webinar for you. We have quite a lot we want to cover today. But before we begin, there's a couple of housekeeping points. Firstly, all microphones and video devices have been disabled and will remain so throughout the webinar. The webinar is scheduled to last around an hour and is being recorded. Questions are encouraged. There's a Q&A tab at the bottom of your screen. Please put your questions on there. There'll be a Q&A session at the end where we'll address as many questions as we can. But please put your name by your question so that if we don't get to it, we can come back to you separately later. We've got quite a lot we want to cover today. The first topic is going to be related to social media, where Anna Robinson and Joe Babos will be speaking about social media and the pitfall from an employment law perspective. And we've seen in the news recently with Gary Lineker how even high-profile people can get themselves in trouble by social media activity. Isabel Boyce is going to be talking about the recent developments in employment law and also the upcoming changes that have been introduced by the Labour government. And finally, Matt Bowtell and Elliott Marsh will be talking about recent developments in immigration. In particular, you would have heard last week the white paper announced by the government and Sakir Starmer, introducing quite substantial changes to the immigration system. So we've got a lot to cover. I don't want to delay any more. So I'm going to hand over now to Anna Robinson, who's going to be talking about social media and employment. Over to you, Anna.
Good morning, everybody. Thank you very much for joining us today. As Devan said, myself and Joe, a new member of our team, will be talking to you about pitfalls associated with employees' use of social media. And I wanted to cover this today because I've noticed we've had a growing number of questions on this topic over the last year or so, which is perhaps unsurprising because so many of us use social media now, typically a combination of both personal platforms and professional platforms like LinkedIn. So what we're seeing is this really interesting blurring of the boundaries between how somebody presents themselves professionally and how they present themselves in their personal life. And you as an employer might not like what you see on somebody's personal platform or indeed their business platform. And what can you do about it? Because obviously people are entitled to a private life. So we will cover the thorny issue where an employee expresses a controversial opinion online. And then Joe will talk to you about what we call side hustles or secondary jobs using the likes of Instagram, which might create a conflict of interest for you, where it impacts on their primary obligations to you. Joe will also talk about cyberbullying and harassment, which we all know is very topical at the moment. And we'll finish by giving you some advice as to how to mitigate the risks with a well-drafted social media policy. Okay, so to start then, I wanted to talk to you about this notoriously tricky area of employment law, which has naturally meant there's been quite a lot of case law on the subject, which is where somebody posts a controversial view or opinion online, and that's brought to your attention. And the question is, what can you do about it, particularly where the view they've expressed might potentially be discriminatory and therefore create a risk in terms of the rights and protections of other members of your workforce. And what we see is this difficult tension between the rights of the individual to freedom of speech and a private opinion, and their own rights under the Equality Act in terms of their right to a religious belief, philosophical belief, versus the potential reputational damage to the business and the rights and protections of others. So the starting point then, if you see something online that you don't like, is to consider whether or not that post or repost by the employee is protected under the Equality Act. And what that means is you have to work out whether or not they have or they're expressing a political or philosophical or religious belief or some other protected belief covered by the Equality Act. Now, that might be straightforward if it's in the context of a political view or a religious view, but some beliefs are not always quite so easy to identify. And so what I thought might be quite interesting at this stage is just to put a little poll question on the screen, if I may, just to test your knowledge as to what constitutes a belief under the Equality Act. Okay, so they're the 5 different types of belief that I've given as potential examples. Just give you a few seconds to input your answer. Okay. Just waiting for the results to come through. Okay, very well done. Most people did get it right. Not everybody got it right, though. The answer is indeed all of the above. And the reason I put that poll question on the screen is because it demonstrates very nicely that the bar is actually quite low, and it's quite easy to meet that definition. The definition was set out in quite an old case now called Granger, which dates back to 2010. And you can see on the slide what the test was in Granger, and I won't go through it in detail, but it's essentially something that's weighty, that has cogency. It's more than just an opinion, it's a belief, and it has to be worthy of respect in a democratic society, so it can't conflict with the fundamental rights of others. So we've seen, for example, in the case law, that very extreme English nationalism views, for example, have not been held to constitute a belief under the Equality Act. But what I would say, and it's worth bearing this in mind, is that even if you find the post offensive or shocking or even disturbing, that does not mean it's incapable of protection. So what you have to do is almost take a step back and separate your own values and set of personal beliefs aside and think more objectively about whether or not you're dealing with a post which gives the employee protection. So if we assume that the employee has discrimination rights, what can you do about it? Well, I'm not suggesting that you can't take disciplinary action. It just makes the situation a bit more tricky. So what I thought might be useful at this stage is just to have a look at some of the cases which we've seen, which make this subject a little bit less abstract and illustrate very nicely the types of considerations you should bear in mind. So the first case, which I'm sure many of you will have read about because it's pretty recent, is the Court of Appeal decision in Higgs and Farmers School. So this concerned a Mrs. Higgs who worked in a secondary school. She wasn't a teacher, she was a pastoral administrator. And what that meant was, as part of her role, she sometimes worked with students who were lesbian, gay, bisexual, and or transgender. And that was obviously quite important in terms of her interactions with the students and how she dealt with that, because sometimes the students were struggling in terms of their sexual orientation. Now, there was no suggestion at any stage that she had acted unprofessionally whilst in the school. Okay, so there were no performance issues at all, but it came to the head teacher's attention because of one of the parents that she had reposted some content on her personal Facebook account, which directly opposed gender fluidity and same-sex marriage. And she did that on more than one occasion. And I'll let you read the types of reposts that she put on her page. but you can see immediately that there's a conflict between what she's expressing in her personal life and what she's espousing in the school. And the head teacher, perhaps unsurprisingly, felt very uncomfortable about this. The response was to describe her comments as discriminatory, a breach of the school's code of conduct, and she was dismissed. So they claimed discrimination, potential discrimination against the students, but she then brought her own discrimination claim, a direct discrimination and harassment complaint on the grounds of her religious and Christian beliefs. So you can see we've got this tension again under the Equality Act. At first instance, and then also at the appeal tribunal stage, the courts agreed with the school, and they felt that, in essence, her role had become untenable. But what sometimes happens with these cases, and why they can be particularly high risk for you as a business, is that she had the support of various lobby groups. And so she was able to fund her further appeal all the way to the Court of Appeal. So, it's just worth bearing in mind that sometimes these types of cases can attract the attention of bigger groups with deeper pockets. At the Court of Appeal stage, they reversed the earlier decision, and they felt, in essence, that the decision was not proportionate. And these are the things that I want you just to think about, because it's really helpful guidance if you have this type of situation. So first of all, whilst the language was objectionable in their view, it wasn't grossly offensive. And that brings me back to the point I made earlier when I was talking about the English nationalism and being capable of defence in a democratic society. It was also relevant that they were reposts, they weren't her own words. And the judges said, well, we don't think anybody reading Mrs. Higgs's personal account, which, by the way, had a different name from her married name that she used at school and didn't name the school at any stage. They said, we don't think for 1 minute anybody will read these reposts and think that somehow they represent the view of Farmers School. Nobody's likely to reach that view. And also, we don't think that her personal views have influenced how she works with the students. So we don't think that the school's reputation's been damaged. And so we don't believe that your response to sack somebody was proportionate. Contrast that with the case of Amuba, which I think is a really interesting decision in terms of going the other way. So this concerned an actress, a Christian actor, who was dismissed following the emergence of Facebook posts in which she had said that homosexuality was a sin and that nobody can be born gay. In a strange sort of twist of fate, Miss Amuba was then cast in the role of Celie, and many of you will know that Celie's a lesbian character in the play The Colour Purple. And as often happens with social media posts, because of their permanency, even though they were old, they resurfaced. And there was a whole uproar, and ticket sales for this play were quite severely impacted. And as a result, she was dismissed, not just by the theatre, but by her agents. Now, in contrast to the earlier case, because there had been this huge impact in terms of the commercial viability of the play, the view of the EAT was that her dismissal in the circumstances was proportionate. So where does this take us then, just to finish up before handing over to Jo? Well, first of all, if you see a post online or a post is brought to your attention that you don't like, think about whether or not the employee has rights under the Equality Act. For example, are they expressing a religious view? And then consider whether or not that's inappropriate or an objectionable manifestation of the belief. So why do you need to take action? Are they criticizing you as an employer? Are they naming you as an employer? Or in some other way, is there a significant reputational damage? Or do you just not like the post because you're worried there might be damage that hasn't actually come to fruition? And then if after considering that you think there is a risk or there is damage, then be proportionate in your response. Do you need to dismiss, or are there other things that you can do? For example, can you ask them to delete the post or issue a written warning? So hopefully that's a bit of a whistle-stop guide as to how to manage those types of situations. And now what I'll do is hand over to Joe, who will talk to you about what we call side hustles. Joe.
Yep, thank you, Anna, and hello, everybody. So yeah, as Anna said, one of the kind of issues that often crops up on social media in an employment context is employees engaging in side hustles or second jobs. And I think it's fair to say that the sort of side hustle second job thing has become particularly more prevalent after the COVID-19 pandemic, where obviously for a period a lot of employees working at home and perhaps had more opportunity to engage in side hustles, and often that would be on social media. So side hustles, I suppose some of them perhaps might not be particularly problematic. Some of them can be very problematic. Their negative impacts can include things like, well, and the employee dedicating significant time and energy to the side hustle instead of investing that time and energy in their primary job. And that can obviously result in things like reduced productivity when performing that main job, and just simply draw their focus away from the sort of dedication you expect in their role for you as their primary employer. Secondly, employees who use their existing skills and experience to develop a side hustle may inadvertently or sometimes even deliberately, I suppose, engage in activities that actually compete with that primary employer's business. And this type of conflict of interest can lead to divided loyalties, and even the employee doing things in competition with or to the detriment of their primary employer's business in the worst cases. Um, Thirdly, as it says on the slide, if an employee is engaging in a side hustle, that might create intellectual property, which there could potentially be a dispute over with their primary employer. And there might also be questions over confidentiality. If the primary employer's confidential information is actually relevant to the second job, the primary employer may be worried that the employee is inappropriately using that confidential information to benefit and develop their side hustle or second job. Finally, if an employee's side hustle involves activities that are perhaps controversial, it can obviously damage their primary employer's reputation, particularly if it garners any attention in the press. As with controversial social media posts on political and societal issues, while side hustles often cannot be completely stopped, there are steps that an employer can take to make them less likely to be a problem. Some of those, or the main ones, include having appropriate provisions in employment contracts on secondary employment, conflicts of interest, confidentiality, and intellectual property, because obviously the employment contract is the main document that governs that employment relationship between the employee and the primary employer. Also, having clear policies to accompany the employment contract regarding things like IP ownership and confidentiality, which will help protect business interests and ensure that any work created during the course of employment remains the property of the primary employer. And also developing, implementing, and communicating other policies, including a social media policy, which set out expectations of professional conduct and define what constitutes a conflict of interest, including guidelines for disclosure. And I think encouraging employees to actually be upfront and disclose their side jobs from the start will help prevent any misunderstandings on each party's behalf. And if you're the primary employer, it might be that side hustle isn't actually a problem at all, and clear dialogue at the start has helped establish that to avoid any issues. Another thing I wanted to touch on is online bullying and harassment in the context of social media. This is because online bullying and harassment can not only damage an employer's reputation, but it can also actually expose it to legal liabilities, because employers can be vicariously liable for their employees' actions when it comes to things like discrimination. This is particularly the case for online sexual harassment following the introduction of the duty on employers to take reasonable steps to prevent sexual harassment, which came into force in October last year. This duty covers sexual harassment by other employees and by third parties, much of which is often carried out online, including on social media, for example. The AHRC guidance provides that employers should develop a robust anti-harassment policy, which includes specific provisions on sexual harassment and should undertake regular risk assessments with continued monitoring of effectiveness. I would say that employers should ensure that online sexual harassment, including on social media, is specifically covered when addressing and trying to make sure that you're complying with this duty. There's several steps that employers can take to prevent online bullying and harassment. The first one of which is providing training to employees on recognizing and reporting online harassment, because regular training helps employees to understand the signs of things like cyberbullying, to know how to properly deal with any incidents. Secondly, establishing clear reporting channels for employees to report online abuse and actually encouraging employees to do so, showing that you're an employer, that you want your employees to raise these issues when they come about. Thirdly, employers should ensure a firm approach is taken to any reported online bullying and harassment by conducting investigations promptly, sensitively, but also fairly. And finally, providing resources and support for employees who've actually experienced cyberbullying, and that can include things like access to counselling services and support groups. So the final part of this part of the webinar, I wanted to go through a bit on what actually should be included in the social media policy, which Anna and I have both referred to several times so far. With the pitfalls that we've discussed in mind, a robust social media policy should, first of all, include clarity on the company's expectations on the use of both personal and professional social media, including examples of what is inappropriate. And I'd say that these examples should not actually relate to content that's on specific political or societal issues, because, as Anna explained previously, these beliefs may actually be protected. Secondly, a social media policy should emphasize the importance of protecting the company's confidential information and intellectual property, again, reinforcing what should already be there in the employment contract and in other policies. An employee should actually be aware that sharing sensitive online information creates significant risks, both for themselves as an employee, but also on their employer. The policy should also include respectful and professional interactions online with reference to the company's anti-harassment and anti-bullying policy. Employees should be reminded to actually treat each other with respect and to avoid engaging in harmful or offensive content online. And finally, the policy should detail what the consequences are of breaches, which will include disciplinary action up to and including summary dismissal for the most serious breaches. So whilst all this content's important, I think it's worth bringing a degree of balance to the conversation and pointing out that employers shouldn't actually go too far by imposing unnecessary restriction on employees' use of social media, because I suppose disproportionate rules can actually undermine employee morale and may even impinge on things like freedom of speech and freedom of expression. Employees that endorse equality, diversity, and inclusion should also be mindful that this covers diversity of thought and beliefs, as well as diversity of other immutable protected characteristics. So employers should not penalise employees for having protected beliefs, which may be different to their own values, provided that they're not expressing those beliefs inappropriately, which Anna touched on earlier. It's also important that the social media policy is regularly reviewed and updated to ensure that it actually stays relevant, because, as we all know, social media is it's evolving. It's a very fast-moving area. The policy should also be non-contractual. It shouldn't be contractual, because if it is contractual, to change it, then an employer will technically need to seek employees' consent, which can be very difficult each time it needs an update. The policy should also be clearly signposted. An employer's intranet page is a good place to do that, because I suppose what's the point of having a comprehensive social media policy if nobody actually reads it or even knows it exists? So yeah, as Anna said, I appreciate that was a bit of a whistle-stop tour, but hopefully you now have a bit of a better understanding of how to navigate some of the key challenges arising from employees' use of social media. But we do appreciate it is a really tricky area. So please remember that we're only a phone call or an email away if you get one of these difficult issues. If one of those comes up and you're not sure what the best way of dealing with it is, as Anna and I have said, there are risks involved, particularly when it comes to things like protected beliefs under the Equality Act. So please do let us know if you've got a tricky issue and you'd like some advice on it. But thanks for listening to this first part of the webinar. I'll now pass you on to Izzy, who is going to deliver our general employment update.
Thanks, Joe. So as we move through 2025, the landscape of employment law in the UK continues to evolve, arguably at a more rapid pace than we've seen in a very long time. I shall begin by going through some recent employment law developments, and then I'll briefly touch on some upcoming proposed changes in the law. So neonatal care, leave and pay. From the 6th of April 2025, parents of babies receiving neonatal care for 7 days or more are entitled to a new form of leave under the Neonatal Care, Leave and Pay Act 2023. This is a day one right, and the leave is paid if employees meet certain eligibility criteria. Employees can take up to 12 weeks of leave and will receive statutory neonatal care pay, which will be granted in addition to existing maternity, paternity, adoption, and shared parental leave entitlements. The leave can be taken at any time within 68 weeks of the baby's birth. Eligible employees will have the right to return to their previous role or a suitable alternative role. Ethnicity and disability pay reporting. A government consultation has been launched on ethnicity and disability pay reporting as part of a broader effort to improve workplace equality. Following the King's Speech in July 2024, the government plans to introduce a bill requiring employers with 250 or more employees to report on ethnicity and disability pay gaps, like the existing gender pay gap reporting obligations. The aim of the consultation is to gather views on how to implement the new requirements. The consultation is open until the 10th of June 2025. The proposed pay gap reporting requirements necessitate that employers start preparing to identify pay disparities based on ethnicity and disability alongside gender. Large companies must ensure that their payroll systems and data collection processes are capable of accurately capturing and reporting this information. Some case updates now. So the first case is Houston and Ofsted. In the case, it's about unfair dismissal. By way of background, a school inspector employed by Ofsted was dismissed following a single incident involving physical contact with a pupil during a school visit. The inspector challenged the dismissal, arguing that there was no clear policy or training addressing such conduct. This case went to the Court of Appeal, which found that the dismissal was unfair. The court highlighted that the absence of a clear written policy or training on the matter meant that dismissal was not justified under these circumstances. So what's the takeaway? Employers should ensure that their dismissal policies are clearly documented and that employees receive appropriate training on expected conduct. The case underscores the importance of having explicit guidelines and training to support fair disciplinary actions. Second case is Sullivan and the Isle of Wight Council in a case of whistleblowing. Miss Sullivan applied for a position within the Isle of Wight Council. During the application process, she raised concerns about potential wrongdoing within the council. Subsequently, she was not offered the job and claimed that this was due to her whistleblowing, seeking protection under the whistleblower legislation. The Court of Appeal determined that whistleblowing protections do not extend to external job applicants. The court reasoned that the position of someone seeking employment is materially different from that of an existing employee. Therefore, Sullivan was not entitled to whistleblower protection in this context. So what's the takeaway? Employers should be aware that under current UK law, whistleblowing protections apply to employees and certain workers, but not to external job applicants. So whilst this ruling clarifies the legal position, organisations may still wish to consider implementing fair recruitment practices that encourage transparency and address concerns during the hiring process. Third case is the For Women Scotland case versus the Scottish ministers. It's about the legal definition of women, and you might have heard a lot on LinkedIn in the press about this recently. The Supreme Court decision in the case of For Women Scotland has received a great deal of attention over the last few weeks. The case is about the gender representation on Public Boards Scotland Act, but revolves around references to sex, man and women in the Equality Act, and whether they can be interpreted in light of the Gender Recognition Act, which allows a person to change their legal sex by obtaining a gender recognition certificate. The judgment is one of many recent high-profile cases dealing with the conflict between gender-critical and transgender rights in the workplace. These cases have established the principle that the holding and appropriate expression of gender-critical beliefs are protected under the Equality Act, and that there's a balance to be struck between such beliefs and the rights of transgender people who are also protected from discrimination and harassment. So what was the case about? The Gender Representation on Public Boards Act is a piece of Scottish legislation which aims to increase the proportion of women on public boards by setting gender representation targets to redress gender imbalances. In its definition of woman, it includes individuals with the protected characteristic of gender reassignment, and this was the subject of the case. For Women Scotland, a feminist organisation, challenged the definition, arguing that women should refer to biological sex as defined in the Equality Act. The Inner House of the Quarter Session initially ruled in favour of the Scottish ministers, a decision which, For Women Scotland, appealed to the Supreme Court, which consequently allowed its appeal. The Supreme Court unanimously ruled that sex under the Equality Act refers to biological sex at birth, not gender identity. This means that for the purposes of the Equality Act, woman refers to a female based on biological sex. The Supreme Court considered that it was important that the Equality Act is interpreted in a clear and consistent way, and that a clear distinction can be maintained between gender reassignment and biological sex in anti-discrimination law. The Supreme Court found that the provisions under the Equality Act, such as those relating to pregnancy, maternity, and single-sex services, can only function logically when interpreted with reference to biological sex, and that an approach based on certified sex would create inconsistencies. The Supreme Court emphasised that its decision does not impact the protection against discrimination on the grounds of gender reassignment, as this remains a protected characteristic under the Equality Act, and it doesn't impact an individual's ability to bring a claim for direct discrimination, indirect discrimination, and harassment on the grounds of perception or associated perception of their acquired gender. So what are the implications of this decision? The ruling has sparked substantial discussions and the potential for future legal challenges. The Supreme Court acknowledged that its decision would have a significant impact on single-sex services and spaces, and that there must be consideration for the distinct needs and disadvantages of biological women and men separately from those of trans people. The Equality and Human Rights Commission has since published interim guidance, highlighting the main consequences of the For Women Scotland judgment for employers and service providers, including in relation to single-sex facilities and services. The guidance states that in workplaces, it is compulsory to provide sufficient single-sex toilets, as well as sufficient single-sex changing and washing facilities where these facilities are needed. In workplaces and in services that are open to the public, transgender women should not be permitted to use the women's facilities, and transgender men should not be permitted to use the men's facilities, as this will mean that there are no longer single-sex facilities, and they must be open to ensure to all users of the appropriate sex. In some circumstances, the law also allows trans women, biological men, not to be permitted to use the men's facilities and trans men not to be permitted to use the women's facilities. However, where facilities are available to both men and women, trans people should not be put in a position where there are no facilities for them to use. Where possible, mixed-sex toilet, washing and changing facilities, in addition to single-sex facilities, should be provided. The interim guidance doesn't state how to address the balance of the provision of single-sex facilities against the rights of trans people not to experience gender reassignment, discrimination and harassment, in particular where there are no suitable or equivalent facilities for them. So claims are still possible because the Equality Act does not give employers the protection from trans-related discrimination that is given to service providers. I will now be discussing some upcoming employment law changes. Following the pledge to introduce legislation within its first 100 days of office, the government published the Employment Rights Bill on the 10th of October 2024. This introduced 28 significant reforms to a range of measures. Amendments to the bill have been made during its progress through Parliament, and most recently on the 5th of March 2025. These sweeping changes are set to reshape the entire landscape of employment law. The majority of reforms are anticipated to take effect from 2026, with some consultations already underway. The bill is currently being considered by the House of Lords. So some of the most significant provisions in the new bill include the day one rights against unfair dismissal. One of the most notable changes is the introduction of a day one right for employees to challenge unfair dismissal without needing a qualifying period. Although the bill does introduce a new concept of initial period of employment, which is essentially a statutory probationary period where employers will be able to follow a modified, lighter touch process to fairly dismiss employees who are unsuitable. Another potential change is in relation to the restrictions on fire and rehire. The bill introduces major changes to how employers manage contract variations using the fire and rehire approach. It will be considered automatically unfair to dismiss an employee for two reasons: if the employer attempts to change the contract without the employee's consent, and also if the employer immediately rehires the same employee or hires another person under a new contract to essentially carry out the same role. There'll be changes to harassment law. The new duty for employers to take reasonable measures to prevent sexual harassment in the workplace became effective in October 2024. The bill proposes additional changes to workplace harassment laws requiring employers to take all reasonable steps to prevent sexual harassment. And it also introduces employer liability for third-party harassment across all types of harassment. There'll be restrictions on the use of 0 hours contracts. The Act proposes limits on 0 hours contracts. Employers will be required to offer guaranteed hours to 0 hours workers after a defined period if they work regular hours, as well as reasonable notice of shifts and compensation for last-minute cancellation or shift changes. There'll be other day one rights introduced as well beyond unfair dismissal. The Act introduces a variety of other day one rights, including an extension to statutory sick pay rights, unpaid parental leave and paternity leave, and as well as a new statutory right to paid bereavement leave and enhanced maternity protections. There are potential changes to flexible working, where the Act introduces new provisions for flexible working, stipulating that employers can only deny requests if they have a reasonable justification for it. And there'll also be the introduction of the Fair Work Agency. So the Employment Rights Bill introduces the Fair Work Agency, which will initially take over certain responsibilities from existing enforcement bodies and will also oversee holiday pay. The Fair Work Agency aims to create a more efficient and unified approach to enforcing employment legislation, providing a single point of contact for both workers and employers. The bill allows for the Fair Work Agency's remit to be expanded to include other employment rights in the future. The Fair Work Agency will have extensive enforcement powers, such as requiring individuals to provide information, entering premises to obtain documents, and compelling employers to provide undertakings with potential criminal penalties for non-compliance. So whilst the shift towards more robust state enforcement is a major development, questions remain about the implementation timeline and whether the Fair Work Agency will have the necessary resources to be effective. So I guess in conclusion, the next few months promise significant changes to UK employment law. Major reforms are anticipated in 2026, but 2025 will be crucial with the passage of the Employment Rights Bill and the start of consultations that will shape the future of employment law. We will monitor these developments closely and we'll keep you updated. I shall now hand over to Elliott, who will be providing you with an immigration update.
Thank you, Isabel, and good morning all. It's a period of significant and far-reaching change for the UK immigration system, and with the government's changes to the immigration rules that came in April, and the publication of a long-awaited white paper a couple of weeks ago, it's fair to say that there's a lot to digest at the moment within the immigration sphere. So what I'm going to do is start by taking you through some of the salient detail in the white paper, and then we'll pivot to look at the wider reforms and the impact that they have on businesses. and then I'll hand over to my colleague Matt, who will look at the pitfalls of immigration compliance in a bit more depth. So, with regards to the white paper, the first question really is, what exactly is the government aiming to do with it? So the overarching goal, the paper tells us, is to tighten the UK immigration rules and to reduce net migration, which has been a political goal of UK governments for the last 20 years. And while we've seen lots of changes in that time, including the introduction of the original points-based system in 2008, the proposals of the white paper, I would say, are perhaps the most far-reaching since the introduction of the PBS back in 2008. So to achieve their goal, what the government's trying to do is to reduce the reliance on overseas labour and restrict immigration within what they deem to be the lower skilled sectors. That in turn is meant to encourage investment into the domestic workforce and attract highly skilled global talent, which they think will bolster innovation and economic growth. And perhaps most importantly, from a political perspective, they want to restore public confidence in the immigration system through a combination of transparency and greater controls. I think we've got to bear in mind that what was published was an early proposal. There'll obviously be weeks and months of clarifications and consultations and developments to chew over before it becomes something that's fit for legislative purpose. But I think irrespective of that, it's hard not to be shocked by the radical changes that will undoubtedly have a profound effect on migrants and businesses alike. So then, what are the changes that are most relevant to this audience, and how are they going to impact the immigration system? So I'll focus on the changes to the skilled worker regime first, as they are probably the most widely applicable to you. So the minimum skill level threshold for skilled workers, that's the employment visa regime, is going to be upped from its current A-level equivalent to graduate level. So that will mean a prioritization of high-skilled roles, and fundamentally it'll carve out lower-skilled roles from the occupations list. And that would see around 180 of the lower-skilled occupations become ineligible once the new rules come into effect. So while the detail hasn't been published yet, our expectation based on that kind of commentary is that the hospitality, logistics, and social care industry is probably going to be the hardest hit. We're also going to see the hiking of the skilled worker salary threshold. So it'll move away from reduced salary thresholds for certain occupations, and it will head towards more of a uniform salary requirement that will apply across the board. Salary thresholds are also going to increase. We don't yet know exactly what the salary figures are going to be or when they'll be implemented, but it's fair to say that the cost implications could be massive for sponsors and for businesses. One figure that we do know at this stage is the immigration skills charge. Those of you who assign skilled worker certificates of sponsorship will know that that's payable for each year of a skilled worker's visa. That is being increased by 32%, which means an annual £320 increase, and sponsors will then pay that as a lump sum at the start of the visa process when they assign that COS. So I think it's fair to say higher wage bills, recruitment costs, and budgeting challenges and sectoral disruption as a result of these are all on the horizon. Taking a slight skew towards more personal immigration. So one of the major changes for people who are seeking to settle in the UK will be the reform of the settlement criteria. Some of you may know the qualifying period for indefinite leave to remain it's currently 5 years. That's going to double to 10 years with the implementation of the white paper. That's going to mean higher sponsorship costs across a decade as there'll be more visa extensions. That could have a potential knock-on for staff retention, where employees may be reluctant to make a longer-term commitment. And that says nothing of the admin burden of additional visa renewals and compliance checks and right-to-work checks that will need to be conducted by the employer during that period. Perhaps the most controversial change that's been proposed is the increase of English language skill level for skilled workers and the wider introduction for the first time of an English language requirement for dependents. So that would mean that dependent family members, so say spouses or partners, would be tested when they get their initial visa and then retested on multiple occasions before they reach settlement to see that their English skill has improved commensurately with the time spent in the UK. I don't feel I really have to overstate the potential impact that could have on staff retention and the UK's general attractiveness to those with families, given it's such a seismic shift from the current position, which certainly for as long as I can remember has been that dependents, certainly at the initial visa stage, are not subject to any English requirement until they reach the sort of settlement and naturalization stage. There are some other changes as well, things like the consolidation of the family visa routes into a single category and the expansion of the global talent and high potential individual visa routes. But I wanted to focus here really on what are likely to be the most heartfelt changes for this audience. So these changes are all part of what's a highly politicized challenge to impose new restrictions on UK immigration. And I think we're seeing the impact of this day to day too. With current government policy becoming more restrictive in recent months. One such change is to conduct retrospective right-to-work checks, potentially penalising and fining employers who have incomplete records or who didn't conduct a right-to-work check at the start of someone's employment, even if that offence happened several years ago. That could mean that a business that realises it hasn't taken a complete right-to-work check could carry out checks today, do everything above board now, in a sort of risk mitigation measure, but the Home Office compliance inspectors could still look at the records, see that the compliance checks were only taken recently, and then penalise the business accordingly. We're seeing that the Home Office are also scrutinising sponsor licence applications particularly closely. We're aware that the current refusal rate for licences is somewhere north of 50%, which is fairly staggering, as that's a real marked increase on what's normally a fairly low level of refusals. And that's particularly prevalent where there is potential for what the Home Office describe as a self-sponsorship scenario. That would tend to apply where you have an individual who's setting up a new UK business and are sponsoring themselves to lead its growth, which is certainly not an uncommon scenario and something that we've dealt with many times. In that scenario, where you have companies at the very beginning of their active and trading operational life, I think it's fair to say that a license application is at a very high risk of refusal now, kind of irrespective of of the amount of investment it's had or its initial success. I think it's certainly at risk of a compliance audit and a potential refusal. So that has placed a significant admin burden on new sponsors, and we're advising people to submit far more comprehensive suites of supporting documents than they may have done initially, certainly pre the policy shift, to address the Home Office's potential queries and to demonstrate that they're active trading and perhaps more crucially now operational in the UK. So that would mean proof of generating revenue, proof of client contracts, and importantly, a proof of an ability to pay staff and to show there's money in the company bank accounts to do that. So the takeaway really is that all businesses should be shoring up their immigration compliance by auditing their records, ensure that all of the checks and balances have been carried out. It's also good practice, I think, for it's good practice for employers to carry out right-to-work checks on all non-direct employees. So people who are working under contract from another company. So if they're on a time-limited contract to complete a particular project, or if they are agency workers, it's good to conduct a right-to-work check so that you can avoid falling foul of the Home Office's scrutiny, in the event that happens. On that note, I'm going to hand over to Matt, who's going to explain a bit more about the compliance regime. So thanks for listening. And as ever, if you have any questions or queries, then do let us know either in the chat or through a follow-up email, and we're always happy to help. Thank you.
Thank you for that, Elliott. Certainly will be interesting times for us over the next few months. As Elliott's mentioned, I'm going to quickly run through some other recent changes and developments to UK immigration policies and procedures, more from sort of compliance housekeeping perspective, but these do risk being dwarfed by the bigger ticket white paper developments, even though they are important and really shouldn't be overlooked. So hopefully starting off with everyone's crowd favorite, compliance audits. Now that we are firmly in the post-COVID landscape and under the new government, UK immigration compliance has become more rigorous. The Home Office is now fully back in the practice of undertaking in-person compliance audits, and notably now frequently uses virtual remote audits as part of its enforcement strategy as well. The latter is used particularly prior to the granting of any kind of new sponsor license, but this dual approach has significantly increased the number of audits being conducted across the board. But all sponsor license holders should operate on the assumption that a planned or unannounced audit, either one, can occur at any time. And the consequences of non-compliance are, needless to say, serious and can range from a license downgrade down to a full revocation. Either outcome would severely restrict a business's ability to recruit or retain sponsored workers, and it would disrupt business continuity and workforce planning. So to mitigate these risks, employers should proactively review their personnel files, ensuring that they align with the latest sponsorship guidance. Conducting a mock compliance audit is also a highly effective way to identify and address any gaps before the Home Office does. But preparation for an audit should now be viewed as essential rather than optional in the current climate. In April of this year, UK visa fees rose again, adding pressure on both businesses and applicants. So the fee for a certificate of sponsorship under the main work routes more than doubled, and it now costs more than £500 per certificate. The skilled worker visa application fee is also increased for both applications submitted from outside and within the UK. And fees for long-term visit visas, global talent, and innovator routes have also increased, with some categories seeing rises of about £100. But at the same time, the Home Office has published new guidance earlier this year that reinforces that sponsors cannot pass the cost of a sponsor license or the immigration skills charge or the certificate of sponsorship fees incurred during the visa application process onto employees being sponsored. This means that employees have to fully absorb those costs regardless of the size of the organization or the duration of the sponsorship. In combination with these cost pressures, with the increased salary thresholds that Elliott mentioned, which are also only due to increase, employers are now often faced with the decision to either raise salaries in order to meet these new thresholds and spend quite a fair amount on visa sponsorship, or reconsider hiring non-UK nationals. These changes are reshaping recruitment strategies and increasing the financial burden of international hiring. And as Elliott also mentioned, with the proposed increase to the immigration skills charge, which was outlined in the white paper, these cost pressures are only due to go upwards over time. The electronic travel authorization scheme, the UK has now rolled this out in its totality as part of its digital border transformation. So this scheme applies to non-visa nationals who are visiting the UK for short stays, including for business trips. While it's not formally a visa, it is a mandatory digital travel permission that must be obtained before travel to the UK. It costs £16 and is valid for 2 years or until the traveller's passport expires, whichever is sooner. But employers who are based in the UK should be aware that business visitors coming in from overseas from eligible countries must apply for an ETA in advance of their travel. Although most applications are normally processed within minutes, the Home Office does advise applying at least 3 working days before the planned departure, just to allow time if they need to conduct any additional checks manually. So it is important to flag this requirement early if you have any overseas colleagues, clients, or partners planning UK visits who are impacted by the ETA scheme, just to avoid last-minute disruptions. For British and Irish nationals, along with anyone who has a formal UK immigration status, they are not subject to the ETA scheme. There's also a distinction between visa and non-visa nationals visiting the UK. So if an individual is required to obtain a visa just for the purposes of visiting the UK based on their nationality, then an ETA is not required. The government publishes a list of nationalities which require visas solely for visits. The UK immigration authorities have also continued their digitalisation programme with the full rollout of electronic visas or e-visas. So this now marks the defined shift away from physical documents like biometric residence permits or visa vignettes towards a fully digital system. So from January of this year, individuals are now required to prove their immigration status through a secure UK Visas and Immigration, or UKVI, online account, which is linked to their passport. The purpose of this shift is twofold, primarily. From one side, to enhance border security and to streamline the user experience. From secondhand, e-visas are more secure than physical documents. They can't be lost, stolen, or tampered with, and they also allow real-time updates to personal details. The digital approach also supports the government's vision of a contactless border, reducing admin burdens and enabling faster, more automated checks from their side. From the employer perspective, you may wish to encourage any visa-holding employees to apply for e-visas if they haven't done so already. I would imagine that most will have already have done this, but it will make various processes for them, namely if they need to return to the UK from overseas travel, more straightforward. And for employees, you should also ensure that you are able to verify an individual's immigration status correctly during right-to-work checks to ensure compliance. On that note, I will hand over to Devan now for the Q&A portion.
Thanks, Matt, and everyone. And I think it's fair to say that there's a lot of change coming in the employment and immigration sphere. A lot has been announced, a lot of it lacking detail at this stage. But I think over the coming sort of year or so, we'll see a lot of change in both areas. Probably the most change we've seen in a very long time in these areas. So moving on to the Q&A now. We've got a couple of questions come in. So if anyone's got any others, please put them in the Q&A function. But this one's for Anna and Joe. So in situations where social media post has not yet caused reputational damage, but has the potential to do so, how should employers weigh the risks and decide on appropriate actions?
Good question. And I think we need to think about the Higgs case here, don't we? Because we're still learning as we go along. I think the cases are very helpful. And what that case, which is very recent, tells me is that it's going to be really quite hard to take disciplinary action or extreme disciplinary action unless you can demonstrate there has been harm to the employer. So, you know, if you see something online that you don't quite like, but it doesn't really have any practical ramifications for you, I think you just need to keep an eye on it as opposed to issuing a sanction. But, you know, it might be that if it's brought to your attention, perhaps because there's been a complaint or because they have a particularly public profile that people have seen and it's not subject to privacy settings, it might be that you have a conversation with the individual. I wouldn't suggest going as far as disciplinary action, but it might be that you suggest to them that there is a risk that people at work might view their profile, and for them just to be conscious of the parameters in your social media policy. And I think it's a good opportunity to draw that policy to the employee's attention, to talk them through it. And then in a way, you're putting a marker in the sand, aren't you? So that if there is an actual risk, an actual problem later down the line, it's more difficult for the individual to say, well, hang on a minute, I didn't know about the policy, or I didn't realize this was an issue in a work context. So I think you might want to do that, but not go as far as to invoke your disciplinary procedure. And I just wanted to add, because I don't think I mentioned it earlier, a bit of practical advice in terms of sort of preventing these issues happening in the first place. You can think about vetting, of course, before you take somebody on, you know, and it might be that you use a third party to do some screening to check somebody's online profile before you make the decision to recruit. Now, I'm not suggesting that's completely risk-free because there's data protection implications, but I think it's inevitably the direction of travel because so many people now are so prolific that to me it's a good insurance policy.
I think that's right, Anna, and I think people are doing it more and more, whether they, you know, and obviously there's data protection implications, as you say,
Yeah.
but I think that sort of pre-vetting and, you know,
Yeah.
where someone has a profile online, I think if you're putting information out there, even as an individual, you've got to be wary of that new employers are potentially going to see it. So
Yeah.
I agree with you. That's where things are moving. I'm just conscious of time. We are happy to stay on and answer a few questions. We've had a few more come through, so we're happy to stay on. Obviously, for those of you who need to drop off, feel free to do so. Just a couple of things before we finalize the questions. You know, there will be a feedback form circulated to everybody, and we'd encourage you and like you to complete that. And I think completing that triggers you being sent the slides, so you'll have a copy of the slides. There will be a recording of this webinar, which will appear on our YouTube channel over the next couple of weeks or so once that's all been finalized. So please be aware of that and look out for that. If you dialed into the webinar by phone and we don't have your name, then you can email events@wfw.com, the same email that sent you the invite, to say you attended, and we'll make sure that you get the slides and everything. So those of you who are dropping off, thank you for joining today. But those of you who can stay on, we've got a few more questions. A hot topic that seems to have come, 3 questions asking variations of the same thing. So it's all around the wait for indefinite leave to remain. And the question everyone seems to be asking is, does it apply to employees who are already in the UK? Does it have retrospective effect? Is it only for new entrants or current skilled workers? And I think Matt's going to pick this one up. Matt.
Yes, I am the £1,000,000 question, the question that everyone was asked as a result of the white paper. The short answer is maybe. The white paper didn't clarify a position either way in terms of whether they want to introduce this retroactively for individuals who are already in the UK on the current path to 5-year settlement. The white paper was accompanied by a technical annex which outlines sort of particular modeling of population statistics that they've done as a result of the proposed changes. And the indication from the annex is that they are potentially looking to introduce this basically with immediate effect. So individuals who are already in the UK on an impacted visa category would be impacted already. It wouldn't just be for new applicants. However, it's incredibly early days. The legislation needs to be drafted. When they've made previous changes to indefinite leave to remain requirements, they've faced legal challenges on the grounds of individuals having the expectation of coming into the UK and expecting to settle within a particular time. So what it will look like when the legislation is actually introduced is still very much up in the air. Obviously, it would impact a lot of people. So people are already raising their concerns about it. So as I said, the short answer is maybe, but it will likely be, I would say, some months until we have the final position clarified.
Yeah. Thanks, Matt. And I think that's right. In the past, they've always had a sort of position where people who are already in the UK, when changes are made, some of the changes don't apply retrospectively. I think this is such a big change. You could envisage a scenario where you've got the main applicant has got their indefinite leave to remain, and then the dependent who joined a few months later all of a sudden misses a cutoff and then has to wait another 5 years. So it'll be interesting to see. I think if they try and apply it retrospectively, I expect to see some legal challenges. That doesn't mean they won't try though, at all. And relating to that, I think generally the changes, there's a further question which Elliott's going to deal with, which is, when are the immigration changes likely to be introduced? There's a lot here, but when are they likely to come in? Is it immediate, or we still got some time?
The basic answer is we don't know, which is effectively what Matt was saying. I think the changes to things like the immigration skills charge, which are more fee related, they can happen at any time, and they do happen at any time because they aren't changes to the legislation, so they don't have to go through the government in the way that the more substantive updates to the immigration rules will. If we're talking about the real kind of meat on the bones of the white paper, I think historically we've seen major changes implemented, typically either in April in line with the financial year, or at the half year end in October. So October could be a possibility. But in all honesty, that's pure speculation. As Matt says, there's a long way to go on this, and that's not even taken into account, as he said, the legal challenges, which people are already kind of collating their concerns and their issues. So I think it's going to be a pretty long road with this one.
Thanks, Elliott. Izzy, there's a question for you. What impact will the change to the qualification period for unfair dismissals claims have? I think that's one of the big changes coming in. So,
yeah, thanks, Devan. I guess the obvious impact is that employees will benefit from increased protection against unfair dismissal from the start of their employment. Obviously, there'll be that initial period of employment where it might be easier for employers to dismiss them. But yeah, this is expected to benefit millions of employees by providing greater job security to them. But given the sort of potential increased number of employment tribunal claims, this is likely to result in I think employers will have to be more careful about the way that they manage their workforce. So, for example, hiring processes and screening is likely to be more thorough to assess candidate suitability. The approach taken to managing employee performance during probation may be a lot more formal and structured and sort of documented more carefully. And I think, you know, the decision about whether someone has passed or failed their probation will be much more carefully sort of considered. And decisions taken by employers kind of in respect of employee suitability or performance will happen a lot more quickly. So employers can take advantage of that sort of initial period of employment. But yeah, whilst the changes are sort of expected to favour employees, their full impact kind of isn't really known yet until the outcome of the consultation. But yeah, it's definitely something to be aware of and keep abreast of.
Yeah, I think that's right, Izzy. I think it's such a big change. And actually, funny, it links back to what Anna was saying about screening your employees, because actually dismissing them later on down the line is going to be a bit more tricky than it was. And perhaps doing checks, perhaps there'll be more rounds to interviews and things such as that. So yeah, I think it will be you know, a massive change, and I think employers will have to change their approach, I think, when it comes to employees right from day one, I think. We've got one final question before we wrap up. Again, this is for Matt. So do we need to carry out retrospective right to work checks on visa holders now that BRP cards are no longer valid, Matt?
Strictly speaking, no, because employers should have been carrying out right to work checks using the online right to work check service for some time now. But I would say it is a good just sort of yardstick time period to go for a cleanup of files and have a look back to sort of do retrospective checks on current employees just to make sure these have been done correctly and in line with the guidance at that time. So strictly speaking, no, but it is a good housekeeping measure, I would say, just to look back and make sure everything's been done correctly and in line with the guidance.
Thanks, Matt. Yeah, so it does mean people have sort of different sort of documentation for people who were employed previously, but that should phase out over time. Thank you, everyone, for that. That brings us to the end of our question session. Thank you to all of you who joined us today. We hope you found it interesting. Please do, you know, put in the feedback form. We'll share the slides and look out for that video. But thank you to all the panelists today, and thank you to all of you who joined us. Have a good morning. Thank you.